paragraphs 1 and 2 constitute a state jail felony. Do you understand what you're charged with here?
Yes, sir.
A state jail felony carries with it, if convicted, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Is that your understanding of the punishment range? 25 CR 1847 is called the State of Texas versus Ebony Chapman. That is you.
Yes, sir.
Present with Mr. Deusley, your attorney, and the state's attorney. And does the defendant waive a formal reading of the indictment and the arraignment here? That's blocked. Can we proceed in summary?
Yes, sir.
In summary, paragraph 1 of this indictment alleges that on or about August 26, 2025, in Jefferson County, Texas, you committed the state jail felony of theft. And it's a state jail felony because even though the value was less than $2,500 in accordance with allegation of paragraph 1, paragraph 2 goes on to have 2 or more prior convictions in county courts at law of thefts. Thus, paragraphs 1 and 2 constitute a state jail felony. Do you understand what you're charged with here?
Yes, sir.
A state jail felony carries with it, if convicted, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Is that your understanding of the punishment range?
Yes.
What is the plan?
The agreement is 2 year state jail to be probated to whatever length of time you feel is appropriate with a $500 fine. No
And-
restitution.
Is that your understanding of the agreement?
Yes, sir.
All right, if I follow that agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead then to paragraphs 1 and 2 of this indictment? Are you guilty of paragraph 1 and or those prior convictions listed in paragraph 2 out of Orange County, Jefferson County, and Calcasieu Parish of thefts? Are those true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to all of this voluntarily and because it is true?
Yes, sir.
Yeah.
I show you what's marked as State's Exhibit 1 here. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered without
No
objection.
objection.
It is made a part of the record for all purposes. In summary, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states.
Yes,
So
sir.
help you God. State's Exhibit 1 is made a part of the record for all purposes. Also, the agreement here is that you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation, which can be up to 5 years in length, fined $500. I've got restitution here in there, but
There's no restitution.
there's no restitution. Is this your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty, in this indictment in paragraphs 1 and 2?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Pre-sentence report is waiting.
Yes.
I'm going to follow this agreement. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1, which is made a part of the record in this hearing for all purposes, to find you guilty beyond a reasonable doubt. I now find you guilty of the state jail felony of theft. And I'm following this agreement. You hereby sentenced to confinement in the state jail for 2 years. That confinement is suspended. You were placed on regular probation for 5 years. Do well, it will be shortened to a third. And a fine of $500 will be assessed. A third of five is about 1 2/3 of a year, so could be less than 2 years. I am signing these documents here. These are the probation orders. It consists of 3 pages. There are 36 conditions and requirements, including you must complete a theft prevention class. Almost all of these requirements are the requirement all of us have to follow, beginning with don't commit an offense. Don't associate with disreputable people. Support your dependents. Ensure that you don't possess drugs and use drugs. I mean, all of these are the kinds of things that we all have to follow. So it's a good thing to begin writing and you get to know what the requirements are. Please follow these. At the end, you do well, then probation will be terminated, hopefully early. If you fail, your probation could be revoked and you could be sentenced up to 2 years in the state jail. Do you understand what's writing on it? Okay. They see the probation officer. Thank you very much. Good luck, man. All right, next.
Thank you.
26 CR 300 is now called. You were Kaylin Chanel Lewis, present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, paragraph 1 of this indictment alleges that on or about February 16th, 2025, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege, though, that you have been convicted of at least two prior DWI, driving while intoxicated, offenses. One on August 18th, 2015, out of the County Court of Law 2 of Jefferson County, Texas, and another August 27th, 2021, in the County Court of Law number 3 of Jefferson County, Texas. Paragraphs 1 and 2 constitute a third-degree felony. 2 or more prior DWI convictions, and you commit a third one, it becomes a felony. Do you understand what you are charged with here? If convicted, they got her as an habitual offender. That can't be right. We need to fix this. This is a third-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty and sentenced to 10 years in prison. That sentence would be suspended. You would be placed on regular probation for up to 10 years in length. You must pay a fine of $500. Also, as a condition of probation, you have to spend at least 10 days in the county jail. Do you understand all of this?
Yes.
And is this your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment? Guilty or not guilty?
Guilty.
You have a soft voice. What'd you say?
Guilty.
Are you pleading guilty voluntarily? that is on your own free will and because you are guilty of what this alleges. And you're guilty.
Yes.
Yes.
Yes, sir.
No. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney?
Yes, sir.
Are the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true as state, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. How do you plead to paragraph 1 charging you with the DWI operating a motor vehicle in a public place while intoxicated on or about February 16th, 2025 in Jefferson County, Texas? Guilty or not guilty?
Guilty.
And paragraph 2, which alleges those prior convictions of DWIs in 2015 and 2021 out of county courts of law of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
Pre-sentence report is ready?
Yes, sir, it is.
I'm going to follow this agreement and find you are pleading guilty voluntarily and truly to paragraphs 1 and 2, which constitute the third-degree felony of operating a motor vehicle while intoxicated. You were doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony as presented in paragraphs 1 and 2 of this indictment. Following this agreement, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That sentence of confinement shall be suspended. You were placed on regular probation for 10 years. It will be shortened if you do well on probation. You must pay a fine of $500. And also, as a condition of probation, you must serve at least 10 days in the county jail. So you will serve 10 days in the county jail on weekends. And I believe the parties have agreed this will begin on May 8th. Is that a Friday?
Yes, sir, it's Friday of next week.
And you will report each Friday thereafter on or before 6:00 p.m. They release you at 6:00 on Sunday. You get 2 days credit. So you're going to have to do 5 weekends
Okay.
in consecutive fashion. Now, there are terms and conditions of probation. And you heard me talk to the previous defendant, which are, there's a fine of $500. That there are several 36 conditions which you must follow, but most of these conditions are conditions we all have to follow. There are certain specific ones that are particular for this type of offense. The probation officer is going to go over with you all of this. Please follow these conditions of probation. If you fail, your probation can be revoked and you can be sentenced up to 10 years of prison. So we don't want that.
It's too much, Your Honor, with all the DWI conditions.
Yeah, okay. Stand by.
Since
Here's this. Thank you.
Thank you, Judge.
Do you date these or do I on these additional terms? The date here. Okay, once you go over with the defendant and she signs, thank you. And this, you must have an auto ignition interlock system installed in any vehicle you operate. Also, you must complete a Texas DWI repeat offender program and pay the associated costs. And I believe this cuts both ways. I believe that program also results in a discount for your insurance. It helps you on your automobile insurance. That will raise because of this offense. And I think this brings it down a little bit, so it makes it tolerable. But that's the price we pay when we, make a mistake. Fix it. This is one of those things you need to fix. This is your third one. How are we doing with the alcohol issue? Do you have that under control? Okay. Please act responsibly. I know you're able to. Okay. Thank you. That is all we can.
The judge ends it with good luck. And he means it. You don't often see judges break it down like that, reminding her that most of these rules are just things everyone should follow. Don't do drugs, support your family, stay away from trouble. It's a simple life, but for someone with a history like Ebony's, it's the hardest thing in the world to maintain. She walked out of that room a free woman today, but she's carrying a 5-year shadow. What do you guys think? Is probation enough for a repeat offender? Or did the system just give her the lifeline she actually needed? Let me know in the comments.